Well, welcome to another YouTube Live. We're going to wait a little longer for a few more people to join on, but as people come in, I want to remind everybody of the format. We are going to do a talk today about how to increase rent without looking greedy, because you can do it, and I want to show you a few strategies in case you're questioning whether or not it's appropriate to raise rent, and then asking yourself, well, how do I actually get this done without turning off great tenants? Because that's the fear, that by raising the rent, all the good tenants are going to take off. And that's not exactly true. So I want to dispel some of these myths. But then I want to get to your questions. I've got about 9 questions today that we're going to get to. And then if you've got a question and you're joining us live and you're thinking, I'd like to know what Ernie thinks about this, particularly if it's on the topic. Hey, James, good to see you. Particularly if it's on the topic, go ahead and just add it to the chat, just like James joined the chat here, and I'll read your question and I'll answer your question to the best of my ability. So today, how to raise rent without looking greedy. Well, there's a couple things you can do that are really helpful to be able to accomplish your goals of raising rent, because you're in this business as a business person looking to make profit. You're not running a charity. And so you want to be able to generate income from your landlording business. And sometimes you're just not making the money, or sometimes you don't know what the right amount of rent is. So before you ever start with a lease, definitely before you ever get tenants, figure out what the market rate for your property is. If you're not sure how to do it, don't guess. One easy thing that you can do is just get online and take a look at what online places like in Houston, we use har.com. You might find realtor.com or Zillow, or even apartments.com if you're doing multifamily, to kind of gauge what your area rents are like. When you're looking for specific square footage of house, number of bedrooms and bathrooms, whether it's a duplex or a triplex or a single family, all these pieces of data are important. What area of town where you're located, all of these factors matter. And so you can do some online research to kind of gauge what the temperature is for rent in your market at any given time. And this is especially important at the beginning of your lease, because you don't want to price yourself out of a market either way too high or way too low. Because once you lock in and you get a lease signed, you're stuck with that rate probably for 12 months, depending on your lease term. So you want to make sure before you ever begin, you set a market rate for your rent. Again, you can use these online databases to do it, but you can also talk to a realtor. And so if you know a realtor who can do comps for you, find comparable prices for comparable units, just like the ones you want to rent, they can give you some insight as to what the market is allowing for rentals just like yours. So along with doing it right before you begin your landlording business, you definitely want to meet market rate in between tenants. The fact that you've rented this unit for $1,500 for the last 10 years is probably a terrible fact. You certainly have to understand that, especially these days, that the rate of inflation makes the value of certain things higher over time. That includes the rent. And so you want to make sure that you are charging the market rate in between tenants. And if you're not, then you're adjusting it so that your next tenant is charged the market rent rate. But let's say you're locked in and you've got a tenant. Can you increase rent in the middle of a lease term? No, you cannot. But if you've got someone who's on a month-to-month term, right, someone who is not locked in for multiple months, you can, with adequate notice, increase the rent for that tenant. But how do you do it in a way that makes sense? Certainly, you don't want to shock your tenant with some extremely high amount. And this sometimes happens because people wait too long before they change the rent, and then they've got to change it a whole lot because their costs are way up and they haven't changed the rent in years. So if you change it, however, incrementally, you're going to get a much better result. Let me give you an example. Hey, Alexander, I didn't see you there. Hello, Mr. Garcia. Good to be here. Glad to have you. I'm glad for all of you who are here. And we're talking about increasing that rent value in a reasonable way. Let's use a 5% rent increase as just a standard. It's not too high. It's not too low. And if you understand the rate of inflation, which has been around 2 to 4%, even here lately, over the last couple of years, 5% ought to cover the rate of inflation and the rise in costs from last year's market level. So you had a tenant, let's say in this example, who was paying $2,000 for rent. I'm using 2,000 because the math's going to be nice and simple. And you decide to raise the rent 5%. That's $100. So that in year 2, the rent is going to be $2,100. And then in year 3, you decide, well, I'm going to raise it another 5%. Now, for you math geniuses out there, I know that an additional 5% should be an additional 5% on that extra 100 too. We're not going to go that deep. We're going to presume that 100 additional dollars is about 5% of the total so far. So that in year 1, we're at 2,000. Year 2, you are 2,100. Year 3, 2,200. Year 4, 2,300. And so that in year 5, you've got a long-term tenant. And in year 5, you're charging $2,400 in rent. Now imagine if you had kept a static rent amount, $2,000 in year 1, in year 2, in year 3, in year 4. When you get to year 5, how is your tenant going to respond if you suddenly raise the rent to $2,400 then? Chances are they're not going to respond very positively. However, the same strategy, if employed over time, gets you to that end result. And get this, if you wait until year 5 to do it, not only might you set off a good rent-paying tenant, because it is a bit of a shock, right? That's a 20% increase, just like that, from their perspective anyway. But not only are you missing out on that if that tenant, takes off, along the way, you've lost $7,200 in small incremental adjustments that you could have experienced over that same course of time. It doesn't make sense to not incrementally increase rent, because not only are you losing out on money, but the moment you need to increase the rent because all of your costs are going up, taxes, insurance, and improvements and maintenance to your property, and once you need to, you end up losing a good tenant and have to go and find somebody to replace them. So again, don't wait, because you don't want that sticker shock. And you also don't want to miss out, again, in this example, $7,200 of additional rent that was collected because the landlord incrementally increased the rent. And finally, the last thing that I would suggest is if you plan to increase rent, sometimes it's extremely helpful to increase that rent alongside upgrades. If, for example, you've had a tenant there for well over a year and you're on a month-to-month, you may say, for example, look, I'm considering raising the rent, but I'm also thinking about updating all of the appliances. I mean, you might have been thinking about doing that either way because the appliances have gotten old and are in need of an upgrade. But by connecting the two ideas, it's less of an impact. It makes sense. They're getting better stuff, and maybe they're paying a higher rate of rent, but they're getting better stuff. And so if you pair a rent increase along with upgrades to the house, maybe new flooring, maybe, I don't know, you do something outside, maybe in the shrubs and the bushes, and people like flowers and what have you. Any upgrade or increase that you add to the property, which also increases your value, can be paired with an increase in rent. And in a lot of ways, your tenant isn't going to mind that increase because it comes with some incentive that they get to enjoy. And so certainly if you're having difficulty just, contemplating a rent increase, you really got to ask yourself, are you making a business decision or an emotional decision? Don't get caught feeling guilty about raising rent. Understand that every year a 5% increase is not that big a deal, but it becomes a big deal when you are forced to increase rent and you end up losing a good rent paying tenant. Or if you can pair it with upgrades, which you were going to do anyway, psychologically, you're showing your tenant that you care about them and that it's not just about an increase in money to you. You want to make sure they have an excellent time on your property and that your property is well maintained. All of this is good business and all of it makes or keeps you in profitability. But if you're falling asleep at the wheel and not increasing rent on a regular basis, you stand to lose money over time and potentially good tenants. So I hope you found this helpful, landlords. Now we're going to get to some questions. Again, for those of you who are here live, I strongly suggest or recommend, if you've got a question, just add it to the chat. I'll be happy to get to it. So, all right, here's the first question. Marcy Haas has asked, if a tenant breaks the lease and leaves and doesn't leave a forwarding address, do you still have to send explanation of not returning the security deposit to them to their last address, which is the rental address? So you ask an interesting question in an interesting way, because unfortunately this does happen. Sometimes tenants just up and go. They leave a mess or they leave damage on the property, and you're like, there's no way I'm sending this deposit back. Well, I always suggest to landlords that you should every single time send that itemized notice of how the security deposit funds were used. Even if all of it was used in just unpaid rent, send that notice. And the reason you send it isn't for the benefit of the tenant. You send it for your own benefit to prevent, potentially, a tenant from saying, oh, you violated the law and didn't send me this notice, and so now I'm going to sue you, and you got to walk into court. And even if you win, you will have spent time and money and effort uselessly. Because you might think, well, I'll just countersue and then collect a big fat judgment against them. Maybe, but if they can't pay off a big fat judgment, again, you've just spent time and effort and energy and probably a lot of money, again, for no real gain. Send that notice every time to the last known address. If you've got an email address, and I strongly encourage landlords to have multiple avenues of communication with their tenants. If you've got an email address, send them an email, let them know how the deposit was used, and that you've got a whole bunch of other charges that potentially could be, sought against them if they ever, and I certainly wouldn't send this in a threatening manner, but that certainly you've got a list of claims that, should you desire to, you could seek from the tenant. This will probably dissuade them from any future litigation against you and some bogus claim that you didn't hold up your end of the bargain. Question 2, SP Jaka asks, what are the chances of getting debt recovered when the court judgment says we can go after them to recover the back rent? Well, that's going to depend on your tenant. That's going to depend on really two factors. Number one, can you locate your tenant? Do you know where they currently reside or where they work? If you can, then it's going to be easier for you to potentially collect your judgment from them. I always recommend, when you've got a judgment, to create a judgment lien. In Texas, we call that an abstract of judgment. You get this additional form after you've got a judgment from the court, and you record personal identifying data for the defendant. In Texas, you add the last three of the social, the last three of the driver's license, and the date of birth, and now you've narrowed it down. So if you sued Jack Smith, well, how many Jack Smiths are there? Well, there's probably only just one with these exact same three social security numbers at the end, same three driver's license, and that exact date of birth. And so in this way, you narrow down which Jack Smith you've sued, and you've established a judgment lien. Now, getting the abstract is just step one. You next have to record it in the same property clerk's records where you record deeds and liens. And now you're recording an abstract of judgment to establish a judgment lien on the debtor in this case. So can you find them? Do you have a judgment lien? But the most important question, particularly in the state of Texas, is do they have the capacity to pay? Because in Texas, you don't have the right to garnish wages from a civil judgment. You just can't. And so what could you do? Well, there's a lot of protections for debtors in this and in many other states. But there's so much protection that if all they have is a homestead, right, they might own a home now, but if it's their homestead, totally exempt, you can't touch the homestead while it's their homestead. If they've got $50,000 worth of personal property or less, you can't touch it. What about vehicles? Let's say they have 4 vehicles registered in their name, and in their home, they've got 3 drivers. So they got 1 extra car. In that case, there's potential there because you could seize one of the vehicles and potentially have it sold at a constable sale to cover your judgment. But if they don't have enough vehicles to cover every driver in that home, it's going to be very difficult for you to collect. Now, if you know of a banking or savings account that they have, it is possible to seize funds out of that account, but you need to know the account, you need to know the institution where it's held, and you need to know the account number. In many instances, it's going to be hard data to get. Not impossible, but it may be difficult. Now, the one good thing, however, about establishing a judgment lien is, let's say in the future, they attempt to buy a house or secure a loan for a vehicle. They might be denied that credit because of this judgment lien. And you might get a phone call and say, hey, what's it going to cost to release this lien? This particular person wants to buy a house. And that's a good day because they want that house bad enough. They might pay your $5,000, $10,000, or $15,000 plus interest in order to get that lien taken off so that they can go and pursue their dreams. So abstracting your judgment is not a terrible idea. You establish a judgment lien, and in the future you might get paid. Your judgment is good for the next 10 years. It can be renewed, but for 10 years at least it'll last. All right, Amina Ibrahim. What's the best way to handle HOA violations that are 100% the tenant's fault, like fines imposed by the HOA for things like leaving trash bins out too long, not maintaining the yard, etc.? That's a great question. It happens way too much, and too many landlords do nothing. And so my recommendation is pretty simple. Once you get the HOA fine, you make a copy of it. You want to keep the original from the HOA. Make a copy of it, or you scan it, or both. And then you deliver that to the tenant and say, this is your fee. You were subject to the HOA as per your lease. And if you want to identify the section, I would do that. But definitely in writing, you're pointing out to them, this is a debt you owe. I'm going to give you 10 days to pay it off. Please submit that payment directly to me at such and such address. And you're saying, Ernie, they're never going to pay that. Maybe. Take a look at your lease. Do you have an application of funds clause? Because if you do, and that 10 days comes and goes, and then thereafter a rent payment is made, guess what they've just done? They have just paid that HOA fine. Now, they may say, no, I paid the rent. I didn't pay that fine. Well, your application of funds clause says you can apply that payment to non-rent obligations first, and then the rest to rent. And so if that's the case and they fight you on it, guess what? You already have a cause of action for eviction. 1, because they violated the lease and incurred this debt. 2, because now they haven't paid the full amount of rent because they owed you that fine first. And now they owe an additional sum in unpaid rent, which if they refuse to pay, may be a sufficient basis for you to sue in the eviction court. And so that's what I would do. Always send these to the tenant and demand payment within a reasonable time. 10 days, 14 days, that's pretty reasonable. Okay. Nekmatin Erbil asks, how much do you charge for an eviction? And I'm presuming he's asking me what I charge when I represent clients in eviction court. It's going to depend on the eviction facts, but our base retainer in a JP eviction is $1,500. Sometimes it doesn't even get to that point, and so we only keep the portion that we earn, but ballpark, it's about $1,500 worth of attorney work when we take on a case. On appeal, we ask for about $1,700. There's a few extra steps on the appeal level. And so if you are in need of an attorney to help you in an eviction matter, we're happy to offer these services. However, by the time you watch this video, it could be 2035, and those fees will have gone up. I'm talking right now in 2025, this is what we charge for these fees. And so you're always encouraged to contact counsel and make sure that even if you're given a base price, that's going to be appropriate for your case. I'll tell you, definitely one thing that's going to increase the cost are going to be filing fees. And so not everybody that we represent requires filing fees because maybe they filed the case first. And so that means we're going to do a little less work. So maybe we won't even hit the full retainer. But sometimes things get complicated if a tenant requests a jury, for example, or they get counsel and counsel, puts on all these motions and requests auxiliary hearings and other things that just kind of increase the workload and increase the time. But generally speaking, right now we're charging about $1,500 for a JP eviction. Number 5, Kimberly Brown Pothos. Kimberly Brown P asks, please explain the Texas tort law in relation to city responsibility for sewer backup following repairs in the area or rain. What qualifies to shield the city as an act of God versus aging of the pipes and frequent problems in various areas that repeat the same problem with sewage backup from the city side? Also to review what qualifies as a flood versus annual spring rain expectations. Wow, that's about 7 questions. I'm going to try to answer everything though. So the Texas Tort Claims Act says that generally speaking, government bodies are immune from lawsuit. However, if you experience harm, either to your person or your property from something, usually that they've used, some tangible item that they've used, then you potentially could be compensated for that. Now, tort claims are like personal injury claims. I don't tend to handle cases like that, but I am familiar with the Texas Tort Claims Act. And so, this happens a lot with cars, mostly. Let's say a police officer while he's or she is doing their job, rams into your car inadvertently. Well, under the Texas Tort Claims Act, the fact that the thing they were using, the car, caused you damage, you might be eligible for some kind of compensation. Now, with pipes, it's a little different. Let's say a city worker was using a wrench and banging a pipe. Well, the use of that wrench in a negligent way might lead to damage to you if that pipe breaks, and that leak causes damage to your home. But just the fact that pipes break and cause damage is probably not enough to result in a negligence claim on the city. An act of God, that's usually weather related or something really just outside the control of the city. Again, just, the land shifting, if the land shifts and breaks a pipe, that's not negligence. And so whenever somebody talks about a force majeure or, some act of God, even acts of war, can't be held against the municipality. I'm not sure about this last part. Also to review what qualifies as a flood versus annual spring rain expectations. I mean, a flood is, when water that's supposed to be outside of your house comes inside of your house. And whether you may be asking an insurance question. I'm not exactly sure what you're asking here. And for this, you're going to want to examine what your insurance policy is, if that's what you're referring to, because they may define flood or flood damage or flood waters in a different way. For example, I talked kind of plainly that, it's water where water's not supposed to be. And so could water flood your home if you let the bathtub overflow? Absolutely. Water could flood your home in that way, but that wouldn't constitute flood water, right? Because flood waters, come from an overflow of naturally flowing water from outside. Maybe a river comes out of its banks, or there's significant rain that, again, enters your home, groundwater or rainwater, but typically bathroom water is not flood water. Okay, so I hope I addressed enough. I addressed enough for you, Kimberly. On to Edward O.B., who asked, my renter's lease runs on August 31st. I plan to give him a non-renewal notice on July 2nd. His late fees and damages have used up almost all of his security deposit. The balance won't even cover 1 month's rent, let alone how much cleaning I'll have to do when he leaves. What can I do if he doesn't pay and milks the eviction? I feel like giving him 60 days notice gives him a blank check to bum me financially. So a couple of things. Never, ever, ever, ever deplete security deposit funds during the tenancy. That security deposit should remain intact until they surrender the premises. It's supposed to be for things like unpaid rent or damages to the property or cleaning the property if they sullied the property in excess of normal use and ordinary wear and tear. And so the first thing that popped right off the page there for me was he has depleted. No. You allowed deductions and it was never necessary to do it. If you're saying, well, what about the late fees? How was I going to collect the late fees? You send a written notice and say you owe late fees. Well, what if he didn't pay? Then you evict, right? So you've always had the power to get it in some better way. In fact, one of the better ways would have been to utilize that application of funds clause. And so if the tenant owed rent or late fees from a prior month, well, then the next month's payment, send written notice and say, by the way, you owe X in late fees from last month. I will deduct that amount from next month's payment in accordance with section X of your lease, which allows me to do so. And even if you get backlash from it, that notice right there is your notice of default. If this happens repeatedly, run to the eviction court. I preach a 3 strikes and you're out rule. Don't let the tenant dictate the rules. Your lease should dictate the rules, and it's your job to enforce the rules in that lease. So that's one thing. But that hasn't happened here, and there's no way to get that security deposit back. That's fine. How do you respond when you have to give a 60-day notice? Well, the moment he fails to pay rent, notice to vacate. Get out. He says, no, dude, blah, 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 blah. Doesn't matter. If he doesn't pay the rent, give him a notice to vacate. I preach 7 days. If by day 7 of that first month of the 60 days, if by day 7 you haven't gotten rent, issue notice to vacate. Give him the 3 days that you're required to give or whatever is required in your jurisdiction. And if he doesn't leave, file the eviction. And maybe you don't have to put up with it for 60 days, right? Maybe you'll be in eviction court by the end of that same month, and then you get him out. Well, what if he appeals? What if he appeals? In Texas, if a tenant appeals, they have to pay an appeal bond. And sometimes that appeal bond is twice the monthly rent. Sometimes if they appeal in some other way, they're required to pay their rent into the court's registry month to month as it comes due. So if you act quickly enough, you can maybe not only minimize your rent losses, you might eliminate them, right? So if you're acting quickly enough and you get a quick enough eviction judgment, even if they file an appeal, they're paying rent into the court's registry month to month as it comes due. And again, you've minimized your losses in that way. You got to act fast, and then you got to follow the terms of your lease. If somebody's paying rent late, don't pull late fees out of the deposit. Always make a written demand for those fees. And then if they don't pay them, pull them out of future rent payments through the application of funds clause every single time. I hope that was helpful. Alexander Valentin. Oh, he's here. Great. Alex, Alexander, I'm coming to you. Here we go. Thank you, Mr. Garcia, for taking the time to educate on your topic. In your experience, what are some common misconceptions tenants have about rent increases? Market justifications. What are the most effective ways for landlords to explain rent increases to tenants without appearing greedy? I'm going to stop there because we got a lot of questions here, and I want to answer them all, Alexander. I hope you're still there. First, what are some common misconceptions tenants have about rent increases? Number one, they misunderstand that your costs also go up. And so this happened a lot in the aftermath of COVID, where tax rates went through the roof because home values went high. That's beginning to level off a little bit, but in many instances, tax rates just went so high, insurance went high, and certainly maintenance costs have risen since COVID. And so that's one misconception, that everything's the same and there's no real need for the rent increase. You're only doing this because you're trying to, suck the life out of me, is a misconception. Tenants don't recognize that costs have gone up for everybody, even for landlords. Another thing that tenants misunderstand is that once a lease has come to an end, you have every right, as long as you've given proper notice, you have every right to increase the rent. You don't need just cause. And in Texas, definitely, you don't really have a rent max. There's no rent control limit in the state of Texas. So if a tenant says, oh, no, you're only allowed to raise it by 2%, I don't know where they got that stat, but it doesn't exist in the state of Texas. In other jurisdictions, maybe, but not here. What are the most effective way for a landlord to explain rent increases to tenants without appearing greedy? Well, to be frank, you don't have to explain anything to your tenant. If they ask for an explanation, again, I would talk about increased tax burden, increased insurance costs, and maintenance for the property. Again, you don't have to roll out invoices to them and say, look, I paid this for the roof, I had to redo the floors, or I power washed the outside of the house or the driveway, or I had to pay for all of the landscaping. That's not really something they can demand from you, nor should you feel in some way obligated to share this with them. You can simply explain that your costs have gone up, or your costs routinely go up, and so in anticipation of those costs going up, the rent will also increase. That you've been doing this long enough, or that you understand the market well enough that these increases are inevitable. Otherwise, if you wait until you're maxed out and you're forced to increase rent, that's when you get the sticker shock that they'll likely be unable to pay, and then end up having to move. And so this works for everybody involved. How can landlords use local market data to justify rent adjustments in a way tenants understand? Again, if your tenant doesn't get it and they refuse to pay extra rent, that's not a very good tenant. And if they require all of this additional work, it's probably time to move along from this particular tenant. But one thing you can do is let them know, hey, if you have questions about what rent values are in the area, you're free to do that research on your own. I've done my own research, and I believe X is an appropriate amount of rent for this particular market. So you can encourage them to do their own research or to seek out their own realtor to test these ideas. Are there specific words or phrases landlords should avoid when notifying tenants about a rent increase? Well, you certainly shouldn't attach it to their behavior or to their conduct, and certainly never say, well, you've just been asking for way too many repairs, because then it starts to sound like retaliation. And so it is retaliatory of a landlord to increase rent because they have requested repairs, particularly if those repairs were necessary, right? And so what you don't want to do is create a situation where you've given them cause to sue you for your retaliation. So not only will you not be able to increase the rent for 6 additional months in accordance with the law, now you might have to pay legal costs, maybe even fees or fines imposed by the court. Not good stuff, not good stuff. So certainly never attach it to the behavior or the lawful requests that your tenant has made. I would always attach it to the market reality and the increase of costs of operation. if at all. If at all. Again, you're not required to justify these increases to your tenants. How important is transparency, and should landlords show tenants a breakdown of rising operating costs? It's not that important. And no, I wouldn't get into the habit of sharing these costs. You may feel less guilty doing it, but I guarantee you a tenant that requires this is not a good tenant. If they can't see it, if it's too complicated for them, they're just not going to get it. And they're going to scrutinize your data, question your data, and then use it against you and say, no, you're limited to this because the data only justifies so much of an increase. I think that's just that's a slippery slope that I wouldn't recommend. Timing and frequency. Is there an ideal frequency of rent increases that landlords should follow to maintain a good tenant relationship? My suggestion is 5% every 12 months. How can landlords balance the need for rent increases with maintaining long-term tenants? I think that incremental increase and then, matching rent increases from time to time with upgrades, these are good things that I think tenants actually appreciate. And so by utilizing these things and other good strategies that you may come upon, it kind of lessens the impact of the rent increase. How can landlords... legal and ethical considerations. Are there any legal risks Texas landlords should be aware of when raising rent? No, except for if you're doing it for a retaliatory purpose. Make sure you understand your own motivation for doing it and not in response to a lawful demand or a lawful request from your tenant. You don't want to get back at them for exercising their rights. That's a recipe for disaster. Do you recommend written scripts or templates for rent increase notices to help landlords maintain professionalism? No, not particularly. Again, you're not required to share this with him. In fact, what you might do is include this in your house rules, that it can be reasonably expected that a rent increase of 5% or greater may be attached to any subsequent leases. And so in that respect, you're kind of, it's anticipated, it's understood that it will happen, that it's part of your regular business. And by making it predictable and making it expected, again, you really have a much lesser degree of impact. Thank you, Ernie, for your insights and practical advice. I'm sure many landlords will find this guidance valuable as they navigate the complex issues of rent increases. I hope they do. Alexander, I like your 5% rent increase guideline. I have a property currently renting at $4,500, which means 5% would be $225. Does this guideline still make sense in this case? Well, that depends if 45 is market rate for your area. If the market rate instead is 35, well, you're going in the wrong direction to increase it further. You may price yourself out of the market. But if the market rate for your unit is actually 48, then you still have a little room, right? I'd get it up to 48 minimally, right? And so do the research, gather your own data. If 45 is good and you're anticipating increases in costs, and I think 5% is a safe bet. But if it's already at 48, I would at the very least match that level for your next tenant or for your current tenant. Again, I don't think it goes that much higher than the 5%. I think you're still in the safe range. Jeffrey Schneider, bigger, and thanks for the info. Best landlord resource on YouTube. Hey, that makes me feel great. Thank you, Jeffrey. I appreciate your kind remarks. Let's go back to questions. Number 8, Makis Kaisaratos asks, if a tenant has moved out 2 months before the lease ends, we have rented the property within 1 month. We have forwarded the itemization of security deposit to the new address showing a balance is due. Damages, unpaid rent, exceeds the security deposit. Can we hire a debt collector agency without having to go to small claims court? Yes, you can. Is that going to be effective? Probably not. Probably not. I've seen little to no return from collection agencies with tenants. It doesn't harm you, especially if they don't charge you upfront costs. If they're going to take a cut of whatever they collect, why not? But again, it comes down to the two-prong test. Can you find them, and do they have the capacity to pay? If both of these are yes, then go after them by all means. But if one or both of these are no, may not be worth it, then yeah, default to a debt collector, and maybe you can get something. But, and this is important, make sure that your numbers are accurate. Don't go throwing in estimates and figure, well, I'm never going to get this anyway, so this thing that costs $1,000 to repair, I'm going to say it's $3,000. How about that? That's bad because in Texas and really everywhere else, that violates debt collection. That violates consumer protections. So you have on the federal level, the FDCPA. On the Texas level, you have the Texas Debt Collection Act. You don't want to charge something that you can't absolutely justify. So don't go inflating numbers. Only stick with what you can actually prove. Okay. But yeah, go to court if you can collect, and if you can find them, and if you can't, yeah, feel free to use a debt collector. But I've seen very little come from that. But if it's no cost, yeah, it's no harm. Dollar Dude, what's the best way to have long-term leases, 3 years, for example, without locking yourself into a fixed rent for that amount of time? Give yourself a step up. And so this happens a lot in commercial leases where you'll have, a company sign a 10-year lease. That lease is going to have a step up year to year where it's already anticipated, a 5 to 10% increase in the rent. Now, with commercial leases, you also have a lot of latitude because typically you can charge things like, and I don't want to get too deep into all this, but you can sign what's called a triple net lease. And so maintenance and taxes and insurance, as those costs go up, you can roll those to your tenant, no problem. It's not the same with residential. So if you do want to lock in a 3-year lease, you should have a step up in rent each of those years. In year 2 and year 3 of at least 5%, depending on again what's appropriate for your situation. But yeah, definitely throw that step up in there so that it's understood that the rent will increase. And if your tenant's fine with that, then by all means. David Burt asks, I'm trying to save a family home that's been in the family since 1976. Its home has a mortgage of $48,800 that is due to my grandfather's estate. The spouse of my aunt got awarded half of the property, and in his will, he gave it to one of the spouse's nephews. I don't understand how this works, but currently the deedee that before siblings of my aunt hold a deed to the property, along with the spouse's estate holding an interest. There are 3 siblings, and they're trying to figure out how they can get ownership. If they have a payoff and other heirs, they feel like they are not entitled to because the sister already took advantage of the father's estate, so they feel like she shouldn't be entitled to any more money than when she already had been given. The 3 brothers are wanting to use the home as a retreat or some way to make extra funds, but all the money made would be going toward the home, getting it where the brothers will each own the home, and they would also be able to make some of the properties. And also the thoughts are of using it as a veterans home, something for the community. Any help, guidance would be greatly appreciated. David, you've got a whole lot of stuff here and so many moving parts. I'd really, really like to help you, but I got to tell you, just from that avalanche of details, I'm not sure who owns what or whose estate still has to be determined. This is the kind of thing that I would strongly recommend you go see and kind of sit down with an attorney where deeds and maybe a will and other things can be reviewed and that, the kind of a back and forth instead of asking all these questions all at once. Maybe start with 1 or 2, and then you may find out that maybe some of these questions are just not relevant because of the answers you get to the first couple of questions. It's really hard for me to wrap my head around all of the issues that are here. And certainly, when it comes to family and heirship, all sorts of things pop up. If there's a debt, a mortgage, for example, and there is a clause in there that it's even possible that the mortgage company can simply foreclose because of the debt of the homeowner. Not the debt, the death is what I meant to say, of the homeowner. So that's also a potential complication. We didn't hear anything about taxes that may or may not be owed on this property. That's also an issue to consider. So definitely sit down and talk with a real estate professional, maybe even a probate attorney. I'm not a probate attorney. You might need to speak to a probate attorney because I'm not sure if grandpa or any of these aunts or uncles left a will and maybe the matter needs to go over to probate. If that's the case, things can get really sticky really fast. And so, this one's probably one that you're going to want to talk to somebody in person about. All right, Alexander, hope you had a good birthday. Saw your Facebook post. Maybe you can introduce your staff. Well, I'll tell you, it wasn't actually my birthday. It was my law firm's birthday. So the law office of Ernie Garcia hit 15. It was actually Monday, but I was in court all day, so we couldn't celebrate till yesterday. But yeah, thank you. I appreciate the birthday wishes. The law office of Ernie Garcia turned 15 just this week, and we're very proud of that. One of these days I'll introduce my staff. One of the things that I'd like to do maybe over the summer is have a staff member join me. We do some of these lives and we can kind of share information together. I'll let them know that you suggested that, and maybe next time I can get them out here. But it's been great talking to all of you guys. I hope you got a ton of information that you can use out of today's live. I look forward to doing these every single Wednesday. However, next Wednesday, I've got an all-day meeting that'll prevent me from doing the live. And so I won't be here on Wednesday, May 14th, but on the 21st, I will be back. And the topic will be, what if the tenant only pays partial rent? You got those partial rent payers. I want to talk about strategies to deal with tenants who only pay partial rent. You got a bunch of strategies. I'm going to give you a few and then talk to you guys about the things that have happened with you and tenants. But until next time, landlords, I wish you all the best. And as always, happy leasing.